What we've done in Oregon is very interesting.
Uh-huh.
Oregon, with the Oregon Task Force on Family Law, developed a tiered model. It's sort of like salmon going up the Columbia, and you have certain tiers that you need to go through. The first is education. Knowledge is power. We require and suggest, or that every court has a information about divorce, about and the effects on kids, so that and how do you develop a parenting plan. We also changed the language, modeling it somewhat after the English 1989 Children's Act, which I had some experience with when they were forming that, and that is that instead of talking about custody, we talk about responsibility. Instead of talking about rights, we talk about responsibilities. That it's that also that it instead of talking about visitation, you don't visit your kid, you parent your child. And we changed the language to parenting time. We also required the parents to develop a parenting plan by the time of the final decree, which put the onus on them, recognizing that they know their children much better than anybody else. It's just that they need some help in kind of working things out. So that's the first step, is the education. Well, the first step is the changing the whole structure of the way you get into the process. And language is important because language determines what you do, and it's a label, and it has some effect on
constructs a reality of
exactly
sorts.
a frame, as it said. So then, so once you've done, if you aren't able to do that on your own, then you go through a mediation that is confidential. You don't make a report to the court. The mediator's there to help you resolve the dispute. And then if you don't work it out there, then you go into an evaluation phase. And the Oregon Family Institute has developed a collaborative evaluation model, which is that the recognition that the family should be the first user of the information, not the last. And that it's not this Academy Award style evaluation where the judge gets the envelope and opens it and says the winner is mom or dad. That it's really that was inappropriate. It really put parents. That a much better approach would be to have an evaluation that would allow the parents to use that information to come up with a plan that's in the best interest of the child. And so what the parents need to do is look at what are the needs of the children, what are the parents' history and capacity to parent, and then what is the parenting plan that matches those needs with the the history and capacity, and how can they work together to achieve this end. It's just a very different way of framing the issues. Then if they're not successful, they go to court. The judge makes the decision based upon the evaluation that now goes forward. And then for the hostility junkies, the people that are having a lot of trouble working it out, we developed a Parents Beyond Conflict group that sort of tried to help the parents learn conflict resolution skills on their own, and to sort of see what the effect is on them. It's a succession model. So it's a series of steps.
Do you think, I'm just curious, do you think you can tell who is and who is not susceptible to be able to mediate before you start?
No.
No. Okay. Tell me why. Tell me what your thoughts are. I've been aware of some testing where the notion is that we can actually tell who will benefit.
Well, you can make a guess at it, but I think that until you've actually given somebody the chance, I mean, there may be some people that can't do it. If you got somebody that's psychotic or is not able to.
Can you think of a case where you've been most surprised? I mean, in other words, in initially meeting this person, inside there's a little piece of you that says, I can't possibly imagine this person can come to an agreement, and they.
Oh yeah, hundreds of them.